Welcome back again. Peter Chow again. Here we have another episode on rental agreement. This one we're going to talk about what happened when the tenant doesn't pay the landlord. The procedure in California is pretty well written. The agreement will cover the rental agreement should cover when the rent will be paid, how much the rent is due. Usually it's on the first of the month, but normally you get a grace period for a few days. You don't have to, but most landlords say, well, it's due on the first, but if you don't pay by the 5th, there will be a late fee, and sometimes there will be a daily penalty fee, okay, on top of all that. So in California, and in I believe the whole country now, there's no such thing as self-help. You cannot just go evict the tenant yourself. There's a whole procedure behind it. Ultimately, you will have to go to court to get them out if they don't move out on their own. That process is called unlawful detainer action. Okay, just remember, no self-help. You cannot just go lock the door and don't let them come in. That would be illegal. In fact, that's criminal. Okay, so now there's many situations that you might want to evict your tenant, right, before the lease expires. But today we talk about exactly one type of situation is when they not pay you. See, when you look at the lease, right? Lease are like an agreement, right? If the tenant does not comply with certain thing in the lease, some of those is called breach. Every time they don't perform, right? But there are two types of breach. One is called curable. The other one is non-curable. The non-curable is like they destroy the property, right? So in those situations, there's no need to give them a chance to fix the problem. But in the other type of situation, it's called curable. It can be fixed. When they don't pay the rent on time, this is one type of situation where it's curable. So what the law requires you to do is to first give your tenant a 3-day notice to pay or quit in California. Okay, it's a piece of paper. You write down the name of the tenant, how much they're behind in rent. You gotta be, if it's more than 1 month, you gotta specify which month and all that, right? And then you add up all the rent that he or she is behind. But you cannot include late fees, penalties, or any damages. Okay, you only put in how much in rent they're behind, really behind. Okay, so let's say it's behind 2 months. Each month is $1,000. So you do that. November 2019, 1,000. December 1st, he or she didn't pay another 1,000, so 2,000, right? So now you evict them based on 2 months. So it's a simple notice. You can go to any website. You can buy it from a stationery store. Fill in the blank, basically. It's pretty self-explanatory. But make sure the amount is correct. What happens if the amount is not correct and he or she didn't move out and you have to file a lawsuit? Those two amounts don't match. The judge will throw out your entire lawsuit, right? Especially in places like LA County, San Francisco County, where they're pretty much pro-tenant. So they're looking for any mistake, okay, that you make on the 3-day notice to throw out the thing, because they have to match between your 3-day notice and your lawsuit later on that you're going to be filing. They have to match. So watch out for those basic mistakes. Make sure you don't make those mistakes. Once it's prepared, you check the math, it's correct, right? So now you have to serve it, meaning giving it to the tenant. Giving the notice to the tenant is called service. Okay? In California, they do allow the landlord himself to serve the 3-day notice on the tenant. But I don't think that's a good idea. Because later on you might have to testify, then the judge might say you're biased. So even though the law doesn't require you to use a professional or a third party at least to serve the lawsuit, but you still should. Okay? Use someone else, neutral. It could be someone you're paying him or her to do it. That's fine. So that person will take the notice to the premises, to the place, right, where the person lives. But the best is the person finds the person there. Give it to him. Like, important thing to know. They don't have to take it from you. Most people say, I don't want that, and try to run away from it. As long as you find the person, you tell them, this is a 3-day notice, right? Preferably you go to the place home, right, with the one that they're renting from you, right? Let's say you cannot find the person there. You may also find a person at work, okay? You find the person at work, you give it to the person at work, okay? So let's say you go there several times, right? You don't find it. I would say, even though law really doesn't require you to do that, I would say try a few times. If you still don't find the person, then what you do, you give it to anyone that you can find at home, right? The place that they're renting from you. The person must be over 18 though, okay? Same thing if you don't find a person at home, you go to a person at work. If you find someone that's older than it must be that you believe to be over 18, preferably you get the person's name. Give it to the person, and then I would say you send another notice out. So you don't find the person who's renting from you, right? So you give it to someone who's at the house, or someone who's at work, who's apparently over 18, that you believe to be over 18, and then immediately you send them a copy. Send your tenant a copy of the notice, right? Now, if you do that though, you will have to add 5 days to the 3 days. So now the 3-day notice become an 8-day notice. Okay. Now let's say you have another situation. You don't find anyone at work. You don't find anyone at home. You don't find anybody at all. So what you should do, you take a copy of the 3-day notice. You put it in what they call a conspicuous place. Okay. Normally what it means is that you put it in the front door. You take some tape it, make sure it's very secure. Okay, tape it there, and then immediately you send out another copy to the same address. Okay, again, you want to add 5 days to it, just to be safe. See, what I'm advising you, some of this is not required by law, but as a matter of practical practice, you should do it. So you expand the 3-day notice into 8-day notice. Okay. So that means within those days, if the tenant wants to pay you, you have to accept the rent. But full amount though, not partial. Okay? You don't have to accept partial rent. Let's say they owe you $2,000 and they offer you $1,500. It's up to you. If you want to take the $1,500, that's fine. But what that means, you have to do another notice for the remaining $500. Okay? The original notice for $2,000 is no longer good because you got $1,500 already, right? So. But you can the law doesn't require you to take a partial payment. You can say, I don't want anything. Until you have the $2,000 together, bring it to me. Okay, that's up to you. So, when you count the 3 days, right, or the 8 days, if you have to do it by mailing, you do not count the day that you service. So let's say you serve the person on January 2nd, right? You don't count that day. And then if the final day falls on a weekend or holiday, you don't count those days either. Right? So you don't count the first day. The first day you start counting is the second day, right? You give it to the person the second, you start counting on the third. Right? Third, fourth, fifth. So let's say the 5th day happens to be on a Sunday or Saturday. Then it goes into Monday now. Or happens to be on a holiday. You have to extend 1 more day. Okay? So those are crucial things you have to know. Okay, so that's pretty much, once you serve that, if you don't get the money within the time period, either the 3 days or the 8 days, now, if the person comes to you the day after, right, with the money, you can say, no, it's too late. I want you out. Okay, I want you out. That's your option. Again, if you take the money, any money at all, you have to start all over again. Okay. So assuming that they didn't pay you on time and all that, now you can move on to the next one. It's called unlawful detainer. This is a court action, right? You actually go to court now. It's a legal action now to move them out. But for this episode, we're gonna end here. So next episode, we're gonna talk about unlawful detainer. Okay, how to proceed with that. Because that's a little more complex now. Okay. Again, if you like our content, subscribe to it, please. Give us a like, and very important, any ideas, anything you want to share with us, anything you would like to hear, learn about, send us an inquiry or email, or comment. Okay, those are always welcome. So we're gonna end here. See you next episode.